Good morning, everyone. Sorry for starting a little bit late. Uh, my name is Fumi Ohana, as already, uh, because I believe it has been messaged to you on the platform, and I'll be your facilitator for today. I'll be taking you business law and what we'll be looking at. We are going to be looking at registration of business and compliance requirements. So let's quickly have a rundown of the, the objective of the course. So one of the objectives is to enable participants have a basic understanding of the nature of the legal system in Nigeria, to enable participants understand the legal regime and regulatory agencies regulating businesses in Nigeria, for participants to know the types of business organization and steps in the formation and registration of businesses in Nigeria, and for participants to have an understanding of the basic nature and elements in a commercial contracts. What are the topics that we are going to look at? We're going to look at to enable participants to have an understanding of the module, so that those objectives raised at the end of the lecture and participants can say they have an understanding of what was taught. So let's one of the topics, we're going to look at the Nigerian legal system. We're going to look at the relevant government agencies regulating businesses in Nigeria, the types of business organizations and legal implication of the various types of business organizations. And we are going to look at registration of business organizations. Then finally, we look at law of contract. So before we discuss what law is, we need to have an understanding of what the Nigerian legal system is. The Nigerian legal system, as it is, we are simply talking about consists of the totality of the laws or legal rules and legal machineries which are obtained within Nigeria as a sovereign country. So when we are talking about the Nigerian legal system as a whole, we are basically talking about all the machineries that are put in place for the purpose of enforcement and of laws in Nigeria, for the purpose of uh, regulating the conduct of members of citizens of Nigeria, and not just and how the country should be governed. When we talk of Nigeria legal system, so this is what we are talking about. So we are talking about the laws that are obtained in Nigeria. You know, we have various laws in Nigeria, and the ground norm, the law which is forms the basis for which other laws are formed, which is the 1999 Constitution, uh, is one of the laws that makes up the Nigerian legal system. Okay, then we have other laws too, like karma, uh, different acts also, found in the laws of the Federation of Nigeria, are also part of the Nigerian legal system. Then we have the various arms of government. We have the judiciary, the executive, and the legislative. Then under the executive, you know, we have various agencies and ministries and MDAs. All they are part of ministries, departments, and agencies of government under the executive arm of government. These are there to ensure that the law is implemented and carried out. That's why we have the police, we have the customs, we have the military. All these ones are there to carry out, to implement the policies and to carry out laws that have been passed in Nigeria. So let's look at the concept of law. I know prior to this class, you all have a basic idea of what law is. You all have a basic idea of what law is. But for the purpose of this class or this module, we are going to have look at the narrow and guarded meaning of law as a rule of human conduct that as a rule of human conduct tacitly or formally accepted by people as binding and backed up by some mechanism for the sustenance of binding nature. So law is there to rule the human conduct. It could not be something that people will sit down and agree about formally. It could be that okay, just by over time, as a result of practice or the other, it became something like okay, if you are to do something, you must do it this way. So it could be tacitly or formally accepted. So for law to be binding, it must be accepted by the people. For instance, the Constitution of Nigeria, if we had not accepted the Constitution, then it would not be binding on us. And there must be mechanism put in place for the sustenance of such laws. That's why we have the various arms of government. They are there to ensure that these laws that govern Nigeria are sustained by using various agencies like police, EFCC, ICPC, the courts, and other means. For instance, in your family, when you make laws, if you make the laws without enforcing them, uh, the laws have no use. So if you say somebody should not do something in your family, you know it's the law. So if you don't go ahead to implement the law, that law exists in a vacuum because there is no, you are not even sustaining the law, so it will not have a binding nature. So that's basically what we are looking at. Then let's quickly look at the sources of Nigerian law. When we are talking about sources of Nigerian law, we're talking about where the Nigerian laws are gotten from. So one of such source is the the English Receipt Law, and the English Receipt Law comprises of the common law, doctrine of equity, uh, and the statute of general application. But for the purpose of this module, we'll just quickly look at the common law and doctrine of equity. So the Receipt English law came into Nigeria as a result of the British colonizers. That is, while Nigeria was being colonized by Britain, they came in with their laws because they felt our customary laws were not suitable for the kind of system of governance they want to use. So they came in with their laws. One of such laws is the common law, and the common law is just like is a law that was developed. It's a part of English law that was developed, uh, was formulated, developed, and administered by the old common law courts in England back then in England. So the common law is more like the cost is a customary law of people of England back then. So how then in England there was nothing called common law. It was after the Norman conquest and the enthronement of King William that the laws in England were unified. And how were the laws unified eventually? It was, course, then itinerant justices. When I say itinerant justices, that is justice that move around from one community to another, do go around from one community to the other in England for the purpose of administering justice. So when they go to a particular community and they see that the custom is good, they will, next time when they go to another community and they encounter similar facts or similar circumstances, instead of using the custom of that particular locality to administer justice, they will use the custom of that other uh, locality which they had administered justice and discovered that okay, their own custom is best suits solves the problem rather than using the custom of those people. So that was how the common law evolved over time. The common law evolved and it was codified as the common law of the old common law of England, and it was administered by the old common law courts. So, however, eventually there was problem with the common law. People were not, litigants were dissatisfied with the remedies they get at common law, and sometimes they cannot even enforce the judgment against certain kind of persons, influential persons in England. So they became dissatisfied with what they are getting at common law courts. So as a result, people began petitioning the crown. So it is as a result of this petitioning of the crown by people of England then that resulted in the development of the doctrine of equity. Because once they petitioned the crown, it was the King's Council that will hear their matter. It's just like, okay, you go to a court A, which is, let me use this example. Court A is a common law. Court B, then Court B eventually became the chancery. So if you go to Court A, you are dissatisfied with the judgment you get back then in England, then you can go to Court B. You can petition Court B. Court B comprises of the King's Council. So if you petition Court B from if you petition the decision of Court A with Court B will hear your matter. So people once they go to Court A and they are not satisfied with the judgment they've gotten, or they cannot enforce the judgment against the litigants, or sorry, against the person they obtained the judgment against, they will go to Court B. And what Court B does is Court B comprises of the King's Council, and the King's Council then there was the Chancellor who was like the head of the King's Council, and the Chancellor then was a priest. So he administered justice based on his priestly background. So if you are dissatisfied with judgment of Court A, you go to Court B. So as a result, doctrine of equity evolved in England. So if we are talking about doctrine of equity, we are not talking about equity in the general sense as fairness. Rather, we are talking about equity in the technical sense, which is that it is the law of England that was developed by the Court of Chancery. Court B, the court I was referring to in my example as Court B, was called the Court of Chancery back then in England. So equity in this context, we are saying that equity is a part of it's part of English law that was developed by the Court of Chancery. That was developed by Court B in code for the purpose of mitigating the harshness of common law. You get it? Because common law became so harsh that to the point that if you are coming to the court, if you don't come properly before the court, maybe you have a matter of theft and you want to come before common law and you are supposed to come, there's a particular document for theft and you went and carry document for battery. If you approach common law will tell you, say, what common law will tell you is that, okay, you are supposed to have used the document for theft, not the document for battery. As a result of that, they will not even entertain your matter. So people became dissatisfied. So that was how the doctrine of equity evolved over time in England. That is why we have maxims like, he who comes to equity must come with clean hands. He who seeks equity must do equity. All these maxims were developed back then as a result of Court of Chancery. So, and these maxims are still applicable in Nigeria and they form part of our laws. Then another source of Nigerian law is the legislation. After Nigeria became independent in 1960, we started operating a unitary system of government whereby we had and we were operating the parliamentary system of government. But over time, we changed to the presidential system, and we have various House of Assemblies at the state levels. Then we have the National Assembly at the national level. This National Assembly, which comprises of the Senate and House of Reps, are there to make laws at national levels. And over time, they have passed so many bills that have been assented to by the president as laws. Example of such bills that have become laws, you have all the universities in Nigeria have their acts. Is it University of Abuja Act, University of all the federal universities have their act, and these were developed as a result of legislation. We have the Company and Allied Matters Act. It used to be a bill, but after it was passed through as law by the National Assembly, it became and assented to by the president. It became a law. So all these are there. Then we have the customary law. The customary law is basically law based on the custom and traditions of the people, whereby people back then in Nigeria where was administered based on their customs and tradition. So the common law is the customary law is just like the English common law. So that's why we have customary courts and area courts in place for the purpose of administering justice based on the customs of the people. So you have a customary judge who is administering a case based on the customs and tradition of the people of that particular locality. For instance, let me give you an example of a notorious custom in Nigeria. It's the Benin customary law of inheritance. The Benin customary law of inheritance is so notorious to the point that it gets to the Supreme Court. The Supreme Court does not even will not even think twice, or it gets to any court, the court will not think twice because that particular custom of inheritance, particularly when it relates to the property the dad was occupying before he died, that one belongs to the first son. So as a result, it belongs to the first son. So if there is a controversy as to who is to inherit that particular property, once it gets to court, the court will just look at precedent that has already been set by Supreme Court that it is the first son. So this custom is so notorious that it is administered even at Supreme Court. So there are other customs too that are still applicable in Nigeria and are still recognized by Nigerian courts. Then we have what we call judicial precedent and case law. Judicial precedent and case law, we have we have three arms of government. We have the judiciary, we have the executive, we have the legislative, arm of government, and we have the judiciary. So the executive, they make the law, the executive implement the law, the legislative arm of government, they are the ones that make the law, while the judiciary interprets the law. So the judiciary, in the course of interpretation, they make the law. Sometimes in the course of interpreting a particular section of the law. For instance, there is a law that says nobody should drive his car by uh, I'm looking for a simple something so that you get how the judiciary make law. Let's say, for instance, there is a law that says uh, every Nigerian should hold on to his face marks, not wear your face marks. Then the matter gets to court. The law particularly states that you should always have your face marks with you. Not that you should always wear your face marks, but always have your face marks with you. So then somebody was walking along the road holding his face mask without wearing it. Then he's apprehended by a task force that says, why is he holding his mask? He's supposed to be wearing the mask instead of holding it. So, for instance, the matter went to court, and the person hires a lawyer, and the lawyer brings the matter before the court, and he cites the law that says you are to hold on to your marks. It's not that you must wear the marks. So in the course of interpretation, the court will say, okay, even though the law says you are to hold on to your marks, but what is the essence of holding on to your marks? The essence of holding on to your marks is to wear it and to prevent the spread of corona. So in that case, even though the law says hold on to your marks, the court can interpret it as you wearing your mask. So in the course of that interpretation, the courts are making laws. So that is how we get some of our laws through case laws. That's why if you go to court, you hear lawyers saying in the case of so versus so person, the Supreme Court decided, despite the fact that we have a law that is governing that particular kind of transaction. So that is how the judiciary interprets law, and that's what we call judicial precedent, where if a higher court decides the matter, other lower courts must follow the precedent set by that court. That means the how that upper court, highest court decided the matter, other courts too must follow suit. When we get to the hierarchy of courts, you get to understand judicial precedent better. So then we have international law. International law also forms part of the sources of Nigerian law. For instance, we have different conventions, treaties, and and some customs, international customs and practices that we have domesticated and they form part of our laws. And there are still some international laws that are still applicable in our own in Nigeria. For instance, the African Charter on Human Rights can be cited in Nigerian courts, and it is an international law. The United Nations Declaration on Human Rights basically forms Chapter 4 of the Nigerian Constitution. So these are sources of Nigerian law. So let's quickly have a rundown of, let's quickly look at the hierarchy of courts in Nigeria. The apex court in Nigeria is the Supreme Court, is the highest court of the land. Once the Supreme Court decides on a matter, it becomes final. There is no any other court that can challenge the decision of the Supreme Court. For instance, if you look at governorship matters, that is matters that have that matters that have to do with election, when they get to the Supreme Court, it becomes final. You will see at tribunal, they will say this person is the winner of the election. For instance, just let's use Imo as an example. The PDP candidate was won the election, where they went to the tribunal, they said he's the winner. They went to court of appeal, they say he's the winner. But when they got to the Supreme Court, because the Supreme Court is the apex court of the land, the Supreme Court said otherwise. The Supreme Court said it's not even the person that came second, that is the governor, rather is the APC candidate that won the election. So that is to show you this how powerful the Supreme Court is as the highest court of the land. So anything that has been decided by the Supreme Court, all other courts in Nigeria, if there is a matter that is similar to the one decided by the Supreme Court, they must always follow what the Supreme Court has decided. Then let us also look at the Court of Appeal. The Court of Appeal is next in hierarchy to the Supreme Court. Is a court that entertains appeals from courts of inferior courts. It entertains appeals, from courts like Federal High Court, State High Court, National Industrial Courts, tribunals. That is governor election tribunals, stack tribunals, or you can appeal to Court of Appeal. So, let me go back a little. The Supreme Court is not all matters. So there are some matters that you can institute directly at the Supreme Court. It's not all matters that you appeal. If you check the Constitution, you get to see those matters that you can institute directly in the Supreme Court. Then let's look at the Federal High Court. The Federal High Court is by virtue of Section 251. It's created by virtue of Section 251 sub 1, I guess, paragraph F of the 1999 Constitution. You will get to see the jurisdiction. When I say jurisdiction, is that the kind of matters that can be entertained by Federal High Court. So if you have a matter you want to go to court, it's not any court you approach. Your lawyer will have to look at the facts of the case. What are the facts of the case and which court he's supposed to approach? Because if you approach a court that does not have jurisdiction, your matter will be struck out. That means the court will say, I cannot hear this matter because I don't have the jurisdiction to hear this matter. So it's important for you to know, okay, this kind of matter, which court do I approach? So the Federal High Court entertains civil and criminal matters, mostly related to federal government agencies and where they are instituted by federal government agencies. Then we have it entertains matters on intellectual property, matters that has to do with interpretation of federal acts like karma. If you want interpretation of karma, you want interpretation of finance act, all federal legislations. So it's the federal high court you approach. The state high courts, they have civil and criminal jurisdiction, unlimited civil and criminal jurisdiction. So to entertain matters, so the state high court cannot entertain matters that are exclusive reserve of the federal high court. As a result, they cannot also entertain matters that relate to that matters that are strictly for national industrial courts or tax appeal tribunals, all the rest. So then we have the National Industrial Court. The National Industrial Court is there to entertain matters regarding employment, matters that have to do with employment, master servant relationship, employer and employee, trade union matters. When you have trade union matters, labor matters, all are supposed to be instituted at this National Industrial Court. All these courts are courts of coordinate jurisdiction. That means you cannot, because judgment is given against you in federal high court, then you say, okay, I want to institute the matter at state high court. If you don't get judgment at state high court and say, oh, I want to institute the matter in no, it does not work that way. You go to the court of appeal. Then we have the Sharia court. The Sharia court is uh, is a court of inferior jurisdiction. It's meant for persons that have submitted themselves to the Islamic personal law. So if you are governed by the if you are governed by Islamic personal law, then you can submit yourself to the jurisdiction of Sharia court. Then we have customary court, as I said earlier. It's administer justice based on the custom and traditions of the people of that particular settings. Then we have magistrate court. Magistrate court is an inferior court of record. It has jurisdiction to entertain civil and criminal matters. In the north, when a magistrate court is entertaining civil matter, is referred to as a district court. But when it is entertaining this thing, criminal matter, is referred to as magistrate court. But it's still the same judge or magistrate that is sitting on the matter. Area courts are just like customary courts. It's just a matter of nomenclature. In the north, they are called area courts. In the north, customary courts are called area courts, while in the south, they are called customary courts. So let's look at civil law. You know, sometimes, I don't know, for those of you that have basic knowledge of law, sometimes you hear people are saying this one is a civil matter, this one is a criminal matter. When we talk of civil law, it just governs relationship between citizens. There are some things that some acts that I will do is not really affecting the society as a whole. It will not affect the order in which the society is being governed. So civil law is just there to uh, regulate the conduct of persons in their interpersonal dealings with each other, conferring status, rights, and obligation on individuals or juristic persons. So that civil law is just there to govern the relationship of persons. It's not like it's there to, like criminal law, where it's there to ensure that the society is the well-being of members of the society. Members of the societies are protected. That means where you commit a crime, like you kill somebody, in that case, the state will take it upon itself, because you are affecting the order in which the state is being governed. So criminal law, on the other hand, is the body of law that relates to crime, and it prescribes conduct perceived as threatening, harmful, and harmful to the welfare and moral of members of the particular society. So when it has to do with civil law, we have civil wrongs like defamation. Defamation, when it can be slander or libel. Slander in the sense that it is said by word of mouth. Libel in the sense that it is printed. That's the difference. So defamation, trespass, if somebody is in exclusive possession of the property, you are not to interrupt with that person's possession. So once you do that, it will be regarded as trespass and is civil in nature. Then we have the Nigerian criminal justice system. We have which is has to do with the criminal law. We have the police, the EFCC, ICPC. That is why sometimes you see some matters they will say EFCC versus social person. If person cause some financial crimes when you embezzle money, public money, that one is affecting the general society. So in that case, that is a criminal matter, and you are not just committing it against an individual. That is why the state will have to take it up with you. So that's why we have EFCC is there to a financial matter. We have ICPC when as a civil servant or person in the private sector, you embezzle public funds. That in its sense is affecting the general public and is criminal in nature. So let's we haven't talked about um, the Nigerian legal system and you having the basic knowledge of what the Nigerian legal system is. I don't expect you to know everything about Nigeria. This is just a summary because the Nigerian legal system is a course on its own. Uh, if you are studying law in any Nigerian university. So this one, what we just treated is just summary of what the Nigerian legal system is. So let's quickly have a rundown of relevant regulatory agencies in Nigeria. What are the relevant regulatory agencies in Nigeria? We have the Corporate Affairs Commission. We'll discuss that in detail. We have the Federal Inland Revenue. We have the Central Bank of Nigeria. Central Bank of Nigeria is the apex bank of the land. And Central Bank of Nigeria, as we know it, is the bank of last resort. So Central Bank was established by the 1978 Act. However, the current legal framework uh, governing the activities of CBN is the CBN Act of 2007. And the Act, and the CBN Act and BOFIA. BOFIA is Bank and Other Financial Institutions Act. Together are administered by the CBN. And the CBN is responsible for rolling out general policy on how the financial institutions, be it money deposit banks and other institutions that do not accept deposit, they are into financial transactions, on how they should go about running their businesses. For instance, recently the CBN banned the use of cryptocurrency because they said it's harmful to the Nigerian economy and the rest. These are policies that are rolled out by the CBN to ensure the general growth of the Nigerian economy. For instance, this particular training you are undergoing uh, is a condition for accessing one of CBN's schemes, which is the agricultural scheme. So these policies are put in place by CBN to ensure the general growth of the Nigerian economy. For instance, the CBN can reduce the lending rate and at the same time increase the lending rate of uh, banks. So these are things that the CBN is responsible for, and it does that to ensure that there is smooth running of the Nigerian economy. Then we have the Asset Management Corporation of Nigeria, which is AMCON. AMCON is established by the 2010 Act. And the purpose, but however, the 2010 Act has been repealed by the 2019 Act because they've done some amendment in 2019. AMCON is there to ensure that there is liquidity flow in the Nigerian financial system. So to ensure that liquidity flow, AMCON uh, severes and manages toxic assets within the Nigerian financial institution. How do they do that? Let me give you an example. With this example, you get to know how AMCON functions. The responsibility of AMCON is simple. Let's say, for instance, Mr. B went to GT Bank and obtained a loan of 1 million naira. When he obtained the loan of 1 million naira, he started servicing the loan, but eventually he encountered the problem and couldn't continue servicing the loan. So over time, there was the interest became very high and everything. He no longer serviced the loan. What AMCON will do is AMCON will just go to GT Bank and say, "Can we have a look at your balance sheet to see those loans, those non-performing loans? Who are those persons that have borrowed money and are not paying?" So they will just look at it. They'll say, "Okay, we are going to buy off the loan from so person." So instead of that person paying the money to GT, AMCON will pay GT that 1 million naira that was plus interest that was borrowed by that person. By doing so, AMCON is ensuring that there is money for other people to access. You know, if you borrow from bank, you are expected to pay so that if others come, they can also have access to the same facility you have access to. So by doing so, AMCON is ensuring that there is liquidity flow within the Nigerian financial system. So now, this Mr. B is now indebted to AMCON and not GT Bank. So if Mr. B has any assets, if there are any assets that AMCON can get hold of to offset the debt, they will go after it. That is why sometimes you hear AMCON has taken over properties of prominent Nigeria, but it does not do that. It will first publish names of persons that are indebted to various financial institutions in Nigeria before it goes ahead to take over their property or anything to offset the debt. Then we have so that's the work of NAV of AMCON. Then we have the National Agency for Food and Drug Administration. We'll also look at that in detail subsequently. Then we have Standard Organization of Nigeria. We'll also look at that too in detail subsequently. Then we have Federal Capital Development Authority or State Commissioner for Lands and Local Government Council. So you know, if you are within the FCT, you know the FCD is a very popular agency of the of AMAC. Or sorry, it is a very popular agency under the Minister of FCT because it administers allocation of land and the rest through one of its agency, which is Aegis and the rest. So if you are within Abuja and you want to carry out any business that has to do with land, you know the appropriate authority to approach to obtain whatever permit you need to obtain, be it for development and the rest. It has to be the FCDA through its various agencies. If you are in another state, you know the appropriate ministry you have to approach. So the reason why we're looking at these relevant regulatory agencies is that uh, if you want to register your business or you have registered your business and you don't know where to go to start. So that is why we need to look at these agencies so that in case you want to register your business, you know, okay, this is the appropriate agency to approach. You want to do your tax clearance, you know, this is the appropriate agency to approach. You want to go into production and manufacture of certain kind of products. You know that okay, if I want to go into manufacture of certain kind of product, I cannot just start distributing my products in the market. I need to go and obtain permission or register with either NAFDAC or Standard Organization of Nigeria. So that is why we're looking at these various regulatory agencies. So what is the response if you want to register a company or you have registered your company? You know the appropriate agency to approach is the Corporate Affairs Commission, and the Corporate Affairs Commission is established by virtue of the CAMA of 1990. However, the recent CAMA in use now is the CAMA 2020, which was signed into law last year by the president. It is a regulatory agency in charge of registration, regulation of business, and non-business organization. So if you want to register your business and non-business organization, you have to use Corporate Affairs Commission. So let's say you want to register a business name, is you approach the Corporate Affairs Commission. If you want to register an IT, let's say you want to register an a non-governmental organization, a church, a mosque, as an incorporated trustee, the appropriate agency to approach government agency is the Corporate Affairs Commission. So what are the functions, or what are the functions of CAC as set out in section 7 sub 1 of CAMA? One of such functions is regulation. One, supervision of the formation. They regulate. If you want to register your company, you have to approach the Corporate Affairs Commission, because you have to register with them the name of the company. The name of the company, you have to register with them. So that is how they supervise the formation of company. And after, you must have submit your application for registration. It is their responsibility to incorporate that company. They will incorporate your company and issue a certificate. Aside that, they will ensure the management of the company where the company is found wanting. And where you feel you don't want to continue with the business or with the company, you can still apply to CAC for it to be wound up. Or if sometimes you contravene the provisions of the law, CAC might approach court, and and they will just ask the court to wind up your company. Another function of CAC is it maintains the company's registry in all states. The fact that you've registered your company, the fact that you've registered your company does not mean you don't have any business with CAC. CAC maintains a registry for your company where you file your annual returns to show that your business is a going concern. If you want to do change of secretaries, change of address, all these are done with the CAC. Also, CAC has the power to carry out investigation into the affairs of any business and non-business organization that is registered with CAC. So if you know at the point of registration, you have to submit what the object of your company or your business organization is. If you are going contrary to those objects, CAC has the right to take over that particular company. Then let's look at the Federal Inland Revenue Service. So the Federal Inland Revenue is the federal government agency in charge of the collection and administration of federal and corporate taxes. So for instance, now you've registered your business, you want to start remitting or paying your taxes, be it company income tax, personal income tax, value added tax, stamp duty tax. All these are federal taxes that are to be remitted to the federal government through the Federal Inland Revenue Service. So if you are running a business, you need to go and register with your local FRS office to be able to remit these taxes I just called to the federal government. So the FRS used to be an arm of the board uh, Federal Board Inland Revenue. Yes, it used to be an arm of the Federal Board of Inland Revenue. However, over time, with the establishment of FIRS by virtue of the Federal Inland Revenue Act Establishment Act of Federal Inland Revenue Service Establishment Act of 2013, the FIRS was separated from the FIDR, where it became an autonomous organ from. So by virtue of that act, FIRS has certain responsibility that were specified by the act. And one of such responsibility responsibility by virtue of Section 2 of the Act. FIRS is to control and administer the different taxes and laws specified in the first schedule of uh, first schedule of the act establishing FIRS. Another function or objectives of another function of FIRS is to administer and enforce the various tax enactments, which are the Company Income Tax Act, the Personal Income Tax Act, the Stamp Duty Act, the Value Added Tax Act. All these are acts that are to be administered the uh, by FIRS. I mentioned different tax enactments that are to be administered by FIRS. But for the purpose of this module, and considering that most of you participants will be going into the businesses that you'll be going into mostly will be into buying and selling. That does not mean if you are running a company, you are not to remit your company's income tax act or personal income tax act to FIRS. But for the purpose of this module, we'll just look at the value added tax, which it has to do with VAT. So when you hear VAT, we are talking about value added tax. So value added tax act is also administered by FIRS. So if you are running a business that has to do with buying and selling, or you are offering any service, you need to be remitting your VAT to the federal government. It does not matter how many times people buy the same kind of product, or you sell that product. If you sell that product 10 times, you must ask, you must, what will I say? You must include VAT in the purchase money for that particular product. And what is VAT? VAT is simply a consumption tax that is levied uh, on a product repeatedly of every point or at every point of sale at value that has been added. That means it's a consumption tax that is levied repeatedly on the product. Repeatedly is being levied on a product. That is, for instance, let me give you an example. Now, if you go to supermarket after buying, let's say you bought a can of Coke, you will see they will tell you the Coke is maybe 150, and they will tell you VAT 5 naira. It's just an example. If you come back again the next hour, you buy the same can of Coke, they will tell you money for the Coke is 150, VAT is 7 naira. So as is a consumption tax that is levied repeatedly on a product at the point of sale. So if you are into the business of buying and selling, or another, it's not just buying and selling, even if you are offering services. For instance, an example that I use of services for those that are using MTN as their network providers, you get to, if you make a call, they will tell you you've called for so seconds, and this is the amount you you have been charged for that call you made, and your VAT is so amount. So all these, they are charging this VAT to remit it to the federal government. It's not theirs, because there is an act that says for every service or product sold, you have to remit value added tax to the federal government, because you are providing a service or selling a particular product that demands you remit VAT. So it is when you want to go into any business that has to do with the supply of products or anything, you need to go to your local Federal Inland Revenue Service office to make inquiries on how you register uh, for VAT, to be remitting your VAT to that particular office. You could decide that it's monthly, that you'll be remitting the VAT. If you will decide it's daily, you will decide it's weekly, depending on the agreement you reach with your local. That depends on the agreement you reach with your local VAT office. However, it's not all products and services that are VATable, because the Finance Act of 2020 provides for such things that are VATable and those ones that are not VATable. Like for instance, on the slide here, if you check, I said cultivation of unprocessed agricultural produce are exempted from VAT and enjoy pioneer status, thus largely exempted from federal taxes. So not every product or services you offer are VATable. So if you want to see those services or products that are not VATable, you could just refer to the Finance Act. So let's look at the Standard Organization of Nigeria. Standard Organization of Nigeria is another agency that is a statutory is a sole body that is vested with the responsibility of standardizing and regulating the quality of product contained in its inventory in Nigeria. Because quality, it's there to regulate, to standardize and regulate the quality of products contained in its inventory. Why I just said contained in its inventory is that the inventory might change as people are producing new products. Standard Organization of Nigeria are releasing new inventory. As long as that product you are producing has to do with one that you need to standardize with the Standard Organization of Nigeria. So if you check out the slides, you get to see the functions of Standard Organization of Nigeria. It's not all products or all products that must be standardized or are regulated by the Standard Organization of Nigeria. Some are regulated by NAFDAC, even though there are also products that could have been easily regulated by Standard Organization of Nigeria. But because the NAFDAC Act specifically states that these are the products, the category of products that are to be administered by NAFDAC, so those ones they are to be administered by NAFDAC. So if you check the slide, you get to see what the functions of the organization is. So you see, if you are into the manufacture or product of any product, you first of all check the inventory of Standard Organization of Nigeria. This product that I want to manufacture, this product that I want to distribute, this product that I want to import into Nigeria, does it fall within the inventory of Standard Organization of Nigeria? And do I need to go and register with them before I start selling? Because the consequences of not registering with them is that they have the powers of seizure. You should check out the responsibility of their responsibility number 8, sorry, function number 8 on the slide. If you fail to register with them and you start distributing your products, the consequences is that they have the power of seizure, confiscation, and destruction of this product. They will destroy the product, and there is nothing you can do about it. Then how can you register with the Standard Organization of Nigeria? So, if you want to register with the Standard Organization of Nigeria, there are procedures for doing so depending on what you are manufacturing. For instance, if you are importing into Nigeria, there is a guideline they have for you to meet before you import a particular product that is regulated by Standard Organization of Nigeria, before you can even start distributing that particular product in Nigeria. If you want to, before you import, if you import the product, before you start distributing the product or selling the product in Nigeria, you will need to check their inventory to see if that products are products that you are to register with the Standard Organization. So the procedure for e-product registration can be for imported or for locally manufactured products. You can see on the slide the procedure is, if you need to create a page, you need to log on to their website, which is sun.gov.ng. You will create a website there. There are details you need to enter. You can see it from 1 to 8. And there are documents you need to to scan. So once you scan these documents, you upload, you make payment, you await the payment of your certificate. There's no time for me to go into the procedure one after the other, as you will have the slide at the end of the lecture to be sent to the WhatsApp platform for you to have. This is just a summary of the procedure on how to go about registering your product with Standard Organization of Nigeria. The way you cannot do it yourself, there are agents around to help you. Then we have another procedure, which is the mandatory conformity assessment program. The mandatory conformity assessment program is a mandatory product certification scheme put in place by Standard Organization of Nigeria to ensure that all locally manufactured products, this one is only applicable to locally manufactured products in the country, conform to the relevant Nigerian industrial standards before such products are presented for sale in the market or exported. So there are procedure for you to do. So if you are manufacturing your product locally and it falls within the inventory of product to be standardized by Standard Organization of Nigeria, there is need for them to carry out this assessment, which they refer to as the mandatory conformity assessment program. So the procedure is there for the mandatory conformity assessment program. They will inspect the problem, sampling, testing, report inspection, the product meets the requirements. They will look at everything. Once it meets all the requirements, your product will be standardized, and I guess you'll be given that a logo, a man card logo will be fixed to a small unit pack of your product. That is to show you that you have certified this thing, you have certified the product, and it can be sold. Then you have another procedure for conformity to ensure that the products you import into Nigeria conform with standards of the conform with Nigerian industrial standards. If they have, the Standard Organization of Nigeria has another program which it calls the Standard Organization of Nigeria Conformity Assessment Programs for goods shipped to Nigeria. So these are all put in place by Standard Organization of Nigeria to ensure that if products you want to distribute in Nigeria that is within their inventory is of standard. So for details on how to go about registering with the Standard Organization of Nigeria, you could just Google same, or you could just go to this website here, www.618biz.com, or you could just Google and you get to see the procedure explained in detail, step by step. And if you need to import products and you want to standardize it with Standard Organization of Nigeria before distributing it or before exporting it out of Nigeria, you can go to www.cortina.com for detailed steps on how to go about doing that, or you could just Google same. So let's quickly look at registration with NAFDAC. NAFDAC has the mandate for controlling, maintaining the distribution, advertising, exportation, importation, manufacture, and registration of the categories of products such as food, drugs, medical devices, cosmetics, etc. So if you see the mandate of NAFDAC, the mandate given by NAFDAC by the NAFDAC Act is there. You can see controlling, maintaining, even advertising. If you want to advertise the categories of products that are within uh, categories of products administered by NAFDAC, then you will have to obtain license from NAFDAC. If you want to run a pharmacy, you need license from NAFDAC. If you want to import a particular food, drugs, medical, you need license. So all businesses in Nigeria that are dealing with food-related products are subject to regulation by NAFDAC, as it is unlawful to market any drugs or any product that is within the categories of products highlighted by the act to be administered by NAFDAC. So if you don't get do the necessary paperwork with NAFDAC, there is no way there is no way your product will be of market value, because even if the product is not confiscated, eventually the price range will be low, because over time people have developed it in their subconscious to check whether this product I'm buying, or this food I'm buying, or this water I'm buying, is it NAFDAC, does 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 is there a NAFDAC registration number? So what are the categories of product administered by NAFDAC? So if you the categories of product administered and that can be registered by NAFDAC, we have food and water, we have drugs and medical devices, we have herbals and cosmetics, we have vaccines and biologics, we have chemicals, we have veterinary products and narcotics. So these are the categories of products that are administered by NAFDAC. So if you are into the distribution or manufacture of any of these things, aside those ones that are for Standard Organization of Nigeria, then and it falls within the categories of products administered by NAFDAC, then you need to register with NAFDAC, even though there can be conflict between Standard Organization of Nigeria and NAFDAC as to which agencies to satisfy what. But something is certain: if you check the act or you check the inventory, the act says based on the NAFDAC Act, if you see that this product you are manufacturing, you must uh, uh, you must register it with NAFDAC. Then just register it with NAFDAC. If you check the inventory of Standard Organization of Nigeria, you see it's one of the products that is listed in their inventory, especially when it comes to devices, medical devices. Then even though is exclusive reserve of NAFDAC to do that, but sometimes we know in Nigeria we can have double standards, whereby one agency is doing the same, two agencies are doing the same thing. To avoid any embarrassment or anything, if you can, you just register with the two uh, organizations. Though, if we are to talk about registration with NAFTA, we cannot exhaust the, the procedure of registration with NAFTA, because we have to look at, for instance, how you register food and water, how you register drugs and medical devices, how you register herbals and cosmetics, how you register vaccines and biologics, how you register chemicals, how you register. So it's going to take the whole of the day. So what I did was just to pick drugs, and let's we simply look at those essential requirements, what are the necessary ones that you need to meet for your drug to be uh, registered with NAFDAC. And the drugs too, I is general. It's not like I picked a particular drug, like I picked a particular drug like medicine for headache or a medicine for stomach ache. I just talked about it generally. So let's though the registration procedure may differ for different products. However, there are just two stages involved in registration with NAFDAC. The two broad stages, which are also divided into sub stages. But the two broad stages, if you want to register your product with NAFDAC, is first is application for approval to bring in samples, where your products are not locally manufactured, where you want to import them to Nigeria, you have to apply for approval to bring in samples. Then two, application for full registration. After, if it is if it's not locally manufactured and you intend to import it after the uh, uh, after the inspection of the samples, the next step is for you to register the product. So it's this registration that I just picked drugs generally, because if you want to register food, the the procedure is still the same. These two stages will still apply. But when you go to the registration, maybe what they will ask you what category of product you want to register. Then there you state okay is now food, water, or anything you want to register. So let's have a look at the this thing. Uh, let's look at have a look at the procedure for registering of drugs with NAFDAC. And when I say drugs in this context, based on the NAFDAC Act, we're talking about medicines, not drugs as in hard drugs. So the first thing, one of the key requirements is you need to know that application is on a single product basis. Application is on a single product basis. This means that if you have two products, let's say you want to register a drug for headache and drug for stomach ache, you cannot just register you cannot just apply for one NAFDAC registration number for the two. Rather, its application is on a single product basis. You apply separately for the medicine for drug, apply separately for the medicine for stomach ache. That's why we said application is on a single product basis. Your written application stating the name of the manufacturer and the brand. You complete your application form where it's a company or any business which is advisable you register, you attach your certificate of incorporation with NAFDAC. So if you are running any business and you are yet to register with NAFDAC, and sorry, you are yet to register the business with CAC, and you've not even registered with NAFDAC, you've not even registered with Standard Organization, then you are risking your business, which you need to take the necessary steps. Then 5 copies of the product dossier. When we say product dossier, that is that particular drugs you want to register. You need to attach 5 copies of the product dossier. And product dossier, we're just saying, okay, before a particular drug is certified as safe, you must have carried out analysis, research. So it's this analysis, research to show that the medicine is effective, is quite effective, and is safe for public consumption. And you need to attach it to NAFDAC for NAFDAC to see how you you were able to achieve that. Then 3 parts of the product samples where you intend to import that particular drug, you need a power of attorney, especially where uh, the drug is manufactured abroad. For instance, we have different vaccines for coronavirus, and you want to uh, import one of such vaccines to Nigeria for for sale to the public. You let's say you want to buy the Johnson and Johnson vaccine from America. You will need a power of attorney from Johnson saying that okay, they've given you the power to distribute Johnson vaccine in Nigeria. Same applies to AstraZeneca. If you want to go to Britain to import as AstraZeneca, you need a power of attorney. Simply, a power of attorney is just a document that is saying that it has empowered you to do an act on behalf of somebody. So that is what we are saying. Certificate of manufacture is also important. Then contract manufacturing agreement with a notary public in that particular country you intend to import the product from, or if you could go to any high commission in Nigeria where that country is a Commonwealth country. Commonwealth countries, their embassies are referred to as high commissions, and their ambassadors are referred to commissioners rather than ambassadors. Then, if absence of the Commonwealth High Commission, you can go to any embassy to notarize that manufacturing agreement or that power of attorney, empowering you to sell a particular drug in Nigeria. Then when you want to run pharmacy to distribute, if you could recall, I said one of the mandate of NAFDAC is to regulate the distribution. So for you to even run a pharmacy, you need a license from or approval from NAFDAC. because it's one of their responsibility. So there are certain documents they require, like the Superintendent Pharmacist license, the premises registration license, the and other things. When you are to import the that drug, let's say that vaccine from America, the Johnson vaccine meant for COVID-19, they will need you to uh, bring the brand name, like certificate, like trademark certificate, registered in Nigeria. This is where intellectual property comes to play. So if you are running a business, you have a logo, you have a name, and over time you've built a reputation with that name. Trademark is not like, if we say register your trademark, we're not saying you should register the mark per se. It's not the mark. What you are trying to protect is the goodwill of the business. Because over time, your business has built a reputation that people associate it with the business, and it's through that mark that we know that, okay, this product is coming from this so company, and over this product of this company has been good. So if you don't register your trademark, you allow somebody to go and register the trademark. What the law is saying, this one I'm giving you free advice. What the law is saying is that that person that registers that mark, that trademark, is the owner of the mark, except you be able to obtain remedy through passing off. Passing off is a thought whereby you use somebody's mark. But this is just by the way I'm saying this. Then you give letter of invitation where you want to import the vaccine from. Let's say the COVID-19 vaccine, the Johnson and Johnson vaccine from America. You give NAFDAC letter of invitation to go and inspect that particular this thing, the particular plant where that vaccine is being manufactured. Then you pay your applicable fee. Also, NAFDAC recently, I guess last year around June, July, introduced e-registration procedure. Rather than going to their office to go and get forms and start filling, you can do such registration online. So you can do it on, you can go to www.napams.org where you sign up. As you can see, the procedure is here, but it's just the summary. I don't know how effective the procedure is, but all this registration procedure, you're saying, oh, do I even have the time to do all these things? Do I even have the know-how and the rest? There are people whose job, and there are lawyers, I know there are a number of lawyers that do such registration, but you have to bear it in mind that if you cannot do it, if they will do it for you, you have to pay them for their professional fee. So we are done with one arm of the lecture. So we are entering the second arm of the lecture, which is also very, very important, which has to do with the types of business organization and the implication of the various types. So what is a business organization? Because time is really against us. We'll just look at the I will not be so detailed in explaining certain things, but what I'll explain, you have an understanding of what I'm saying. So let's say we are talking about business organization. When we say business organization, we're talking about a legitimate venture to make profit. And what are the types of business organizations we have? We have what we call sole proprietorship, we have partnership, we have company. And what are the legal implications? So, excuse me. So, as the name implies, sole proprietorship. Sole proprietorship means one person. So, one person running his business, taking his decisions without consulting with any other person. So, what are the legal implications of running a sole proprietorship? One of the legal implications is that when you die, the business dies with you. Two is when you borrow money from any financial institution and you are unable to repay that money, they can come after you personally. They will come after your personal belonging because they are running a sole proprietorship. So the sole owner is personally liable for the debt and liabilities of the business. Your personal asset, properties, all can come for. For instance, Mr. Johnson, who runs Johnson Business Venture, decides to borrow money from Skyron Bank. And because he borrows money from Skyron Bank and he's unable to pay, they go to the Skyron went to bank and obtained judgment. In that case, he, if they get the judgment, they will come and enforce the judgment against Mr. Johnson, and they can, in enforcing the judgment to recover the judgment sum, they can go after his personal belongings. They can come to his house to seize his bed sheets, his beddings, his refrigerators, gas cookers, washing machine, anything they can lay their hands on to offset the debt. And the fact that you register your business with the CAC, as long as it's a business name, as a sole proprietorship, does not separate you from, does not give the business that separate legal personality. The business is still one and the same with the owner. Then another form of business organization is partnership. We have different types of partnership. It can be limited partnership, it can be limited partnership, it can be general partnership, and it can be limited liability partnership. You see, all these are partnership, but what are the, we know partners is when two or more persons come together, partnership or partners, two or more persons come together to run a business, maybe, or to run a service for the purpose of making profit too. So once if the type of partnership you decide to run determines the kind of partnership you go into will determine how it is being run. For instance, let's start with general partners. Like if you guys decide to go into partnership, let's say Mr. Johnson and Mr. John today decide that they want to go into partnership, and each person says he wants to be a general partner. Mr. Johnson says he wants to be a general partner, and Mr. John says he wants to be a general partner. They are both running a general partnership now. The implication is that one, just like sole proprietorship, they can come after their belongings when they are indebted to any organization or a financial institution. And when you say you are a general partner, that means you are involved in the day-to-day running of the business. Every day, none of you is both parties are active in the running of the business. If Mr. John is active, he plays a major role in the running of the business. Mr. Johnson also plays a major role in the business. So if you borrow any money, it's going to be, and you are unable to pay, they can come after your personal belongings. That, let's say GT will come after your personal belongings, your beddings, your cars. So Mr. Johnson and Mr. John, they are personally liable. So anywhere you see personally liable, that means they can come for their cars, their beddings, their gas cookers, their washing machines, anything belonging to them personally. So that's why we said, I say here, I said, I sorry, that's why I wrote here, general partners are at risk of having their personal belongings seized to offset the debt and liabilities of partnership business, because it's a business made up of two or more partners, each sharing the business's, this apostrophe S is not supposed to be here because it's businesses, so the apostrophe should be in front. I apologize for that. After the lecture, I'll do the correction. Debts, liabilities, and assets. So that's general partnership for you. Then we have limited partnership. Limited partnership. So if you get the note, if you can edit it, you can just remove the S in front of the business. And then on the other hand, when we talk about limited partnership, let me still use the example of Mr. John and Mr. Johnson. They agree that they want to run a partnership, but Mr. John approaches Mr. Johnson and said, see, I'm a very busy man. I cannot be involved in the day-to-day running of this business, even though we've agreed that we are going to run a partnership. But what I can do for you is that I just want to invest, but I don't want to be involved in the day-to-day running of this partnership. So, but that's why I have it here that a limited partnership exists when two or more partners go into business together, but one or more of the partners are only liable up to the amount of investment. So Mr. John says, I can only invest, but I don't want to be involved in the day-to-day running of the business. So what happens? What happens here is that, okay, he's not involved in the day-to-day running of the business, but he has investment in the business. Then Mr. Johnson goes ahead and borrows money. Mr. Johnson goes ahead and borrows money from a financial institution. So him, Mr. Johnson, being involved in the day-to-day running of the business, if they are unable to pay that money, the bank will come after Mr. Johnson personally. So Mr. Johnson will be personally liable in the sense that his personal belongings can be seized to offset the debt. But as for Mr. John, who is a limited partner, they cannot come after his personal belonging. They can only come after his investment in the business because from the onset he said he does not want to be involved in the day-to-day running of the business. Rather, he just wants to be a limited partner. So that's the difference between general partnership and limited partnership. Then we have a limited liability partnership, which is a hybrid in the sense that it's a combination of partnership and company. But it's mostly applicable to when people want to provide services like accounting firms, law firms, consultancy firms. That is when you see them running limited liability partnership. Limited liability partnership in the sense that the partnership as a body is separate from the persons running the partnership. So if Mr. Johnson and Mr. John decide today they want to run an LLP, it means that they will not be personally liable where they are indebted to any uh, financial institution. Why will they not be personally liable? The reasons are one, the legal implication of LLP is that partners enjoy limited liability. Where the entity is sued, the liability of its partners will be limited only to the amount contributed by each partner for the formation of the LLP. And the LLP enjoys perpetual succession. That means it lives forever and is not affected by the demise, retirement, insolvency, or withdrawal of any of the partners, except expressly agreed otherwise. Profits in partnership are to be shared equally. Let's before we come to this, let's look at LLP. So Mr. John and Mr. Johnson are running LLP. They both invested. They both contributed to the formation of the LLP. So if they're indebted to any financial institution, the LLP being a separate legal personality, in the sense that it is a legal personality on its own, it can own properties, it can sue other entities too as an LLP. So that bank cannot come after their personal belonging. Rather, the bank will come after those assets that are bought in the name of the LLP to offset its debt. So these are the various types of partnership. So based on this now, if you want to go into any business, you have an idea of, okay, this is the kind of partnership I want to go into. And mind you that if you are going into any partnership, if you are if the profit is not shared equally, then you are not a partner in that business. Except you guys agree otherwise, uh, then it's permissible. Now, where the agreement is not otherwise, where there is no agreement on ground as to the fact that profit is to be shared equally, then the partner, if you are just a partner by your own assumption, but in the eyes of the law, you are not a partner. So you must insist that profit must be shared equally. Uh, as I said, who is a partner in a business is whether the person partakes in profit sharing. If you are being paid for being a partner, you don't partake in the profit sharing. You cannot be said to be a partner. Then one of another business organization is companies. Companies do too have a legal implication. And you see one thing with companies have a legal personality, just like LLP. At the moment you want to, let's say Mr. Johnson is running Johnson Ventures business as a business name, and he decides to operate it to a company. Once Mr. Johnson is issued with certificate of incorporation by the Corporate Affairs Commission, that business he was running as Johnson Business Venture, he decided that he was going to upgrade it and register it as a company, and he upgraded it to Johnson Nigerian Limited. Johnson Nigerian Limited is separate from Mr. Johnson. Johnson Nigerian Limited is a person in the eyes of law. It's an artificial person. So anything that Mr. Johnson can do as a person in terms of business, Mr. Johnson Nigeria Limited can also do. So that is why Mr. Johnson, at the point of incorporation, the fact that he was the one that paid for the registration of the company, the fact that he was the one that promoted the company, the fact that it is his name that whatever, it does not matter. Once a certificate of incorporation is issued, Johnson Nigeria Limited becomes an artificial person, and Mr. Johnson only becomes a shareholder in that company, and his liabilities limited to his investment in that company. If there are other shareholders, so also are their liabilities limited to their investment in that company. If the highest Mr. Johnson can decide to be aside being a shareholder, he can decide that he wants to be a director, and that's just it. Any other thing, if the company borrows, what are those things that the company can do in its own name? As you can see, it can buy and own properties. If you check some C of O's, you will see that instead of the C of O being in the name of a person, you see it appearing in the name of a company. That is to show you that that company is an artificial person. You will see companies entering into contract. You will see this is an agreement between Johnson Nigerian Limited and Claudia Nigerian Limited. All these are things that you can do with companies. You can sue and be sued. When you see some cases in court, you see this case of Johnson Nigerian Limited versus the federal government of Nigeria, Johnson Nigerian Limited versus, you get it. So this is to show you that these companies are in law referred to artificial persons, so they can carry out all these things. Then they enjoy perpetual succession. Perpetual succession in the sense that it lives forever. I love to use the example of First Bank when it comes to perpetual succession. If you check the logo of First Bank, I think you will see since 1894. Are you telling me the people that started First Bank are still alive? Or the initial shareholders are still alive? Or the original forever. So when you decide to register a company, if today your company is going well, you can decide network. Sorry for that brief interpretation, interruption. interruption. Sorry. So, as I was saying, you can apply for loan in the name of that company. So, these are some of the advantages of registering, the legal implication of registering a company. You are not personally liable, they cannot come after your asset. But this is just general in situations where there is fraud. There's what we call in law called lifting the veil. The court will apply lifting the veil to see who are the persons behind this company, so that they will get to unmask those responsible for the fraud. So if you register your company, don't go and use it for fraud, saying you are separate from the company. If you do that, if the long arm of the law comes against you, don't say the law says, or one of your facilitators said you should the legal personality of the company is separate from you. So, because we cannot prosecute companies for crime, and the persons that are responsible for manufacturing the company. Then let's quickly have a look at registration of business and non-business organization. Let's see, why do we have to register our business? So as you can see on the slide, first, as said earlier, CAC is responsible for registering business. Whether you benefit from, if you register corporate, physical, and product registration, if you register with them, you get to benefit some incentives by the federal government. Example, like during this COVID-19, there are some policies that were rolled out by federal government with the aim, through the CBN, with the aim of helping small and medium enterprises so that they could cover up for losses suffered as a result of the pandemic. Even though I don't know how effective or it really got to those businesses, but I can say in abroad, those ones are due to their system, the kind of transparent system they run, and the kind of government, the accountability and everything. Small and medium scale enterprises can say they've gotten that in such incentives. That is why in such countries, to pay your tax, you don't find it difficult to do so, because when there are things like that, in the case of pandemic, people be helped by the government. Aside incentives and other benefits, if you don't register with SON or standard with NAFDAC, it will affect the marketability of your product. Because if I check your product, there's supposed to be logo of ManCap, or there's supposed to be Standard Organization of Nigerian logo. It's not there. I'll be discouraged to buy that product, especially if I'm a person that knows that this product is contained in the inventory of Sun, or this product is among the category of products that are to be registered with NAFDAC. Aside that, your product might be confiscated by NAFDAC. Your product might be confiscated by NAFDAC because you failed to register with them. Then, small business startup procedure. You find a suitable business name, support your business idea, identify suitable business location, register the business with CAC, uh, you register with FIRS for value added tax and other taxes like your company income tax and the rest. Register your product with NAFDAC where you need to, or register with Standard Organization of Nigeria. CAC, Corporate Affairs Commission first. Though there are names, we will talk about registration procedure with CAC right now. So before we discuss this particular procedure, of registration with CAC, I want us to look at something. Let's first of all discuss. Uh, let's first of all discuss the kind of businesses you can register with CAC. You see, with CAC, you can register a business name, you can register a company, you can register incorporated trustees, so like churches, NGOs, mosques, and other things. You can register limited LLP, that is limited limited liability partnership LLP. These are things you can register with CAC, but for the purpose of this module, I'm considering the kind of businesses that most persons, participants in this program will do. We are going to streamline ourselves to just business name and company. So business name, you can register business name as a sole proprietorship or as a partnership. Sole proprietorship if you are the only one going into the business. Partnership if you are going into the business with another person. So, so the first thing you need to know to do with CAC is reservation of name. I'm going to I'm going to tell you how you go about doing this registration yourself. You can, because CAC has made provision whereby you can do it yourself. You don't need any person. You can do it yourself, and you can also use agents. There are agents where you feel you can't do it yourself, you don't have the time, or you don't have the know-how to do it yourself, you can use agents. And who are those agents that you can use to register your company or business name with CAC? You can use lawyers, you can use chartered secretaries, you can use uh, chartered accountants who are registered with the Corporate Affairs Commission. So they normally have an ID card. So to that effect, to show that okay, I'm registered with the Corporate Affairs Commission and I can register your company for you. And they usually have a portal. Like me, I have my own portal, I have my own this thing. So these are agents. But CZ has made provision where you can register yourself. So I'm going to give you a breakdown of this procedure on how to do. The first thing you need to do, if you want to, you need to create an account. You need to create an account for yourself if you want to register the business yourself. You need to go to CAC website. If you go to registration, when you go to their website, I wish I could. I wish there is a way we will have a slide that will show you step by step of how to do it on their website. But I will just say it orally. You go to their website, you go to registration. When you go to registration, you click on registration, you get to see online registration. You click on online registration on their site. Then you see where it will give you option of logging in, option of creating account. When you go down, when you check there, just do a thorough check of the website. You see where it will give you an option of creating an account. So it's that place where you are creating an account, you get to enter your details. And the persons that can create an account is you are creating that account for the purpose of registering your business yourself. That account is just for the purpose of registering that your company or registering that your business name yourself. You cannot register for somebody using that account you are creating. It's only agents that can register for thousands and thousands of people using their portal. But if you are not an agent, you can only register your business. So you go, you create an account. After creating an account, then you sign up where you sign up and create your portal with CAC, where you'll be given a username and a password. So it's that username and password you'll be using to to carry out your registration. That is why here on the slide I have reservation of name on CAC portal, reservation of name on CAC portal, reservation of name on CAC portal. So you are going to reserve the name on CAC portal. You enter your portal, then you go to new registration. When you click on, okay, sorry, you click on new name reservation. You click on new name reservation. Once you click on new name reservation, if it is a business name you want to register, it will you select business name. If it is a company, if it is partnership, you will select it. Then if it is business name, you click on business name. CAC will ask you, is it sole proprietorship or partnership you want to register? Then you tell them sole proprietorship or partnership. Then you have to reserve that particular, and there are names that cannot be reserved. You cannot reserve a name that is in use. You cannot reserve a name that is similar to another name. CAC will not accept it. And there are restricted names, names that you need to get the consent of RG or consent of a particular institution before you can use that particular names. So these are names that you cannot use. Then you, after you must have reserved that name, you will wait. If CC, then there is a fee you pay for reservation of name. After you've paid that fee for reservation of name, then you wait for CAC to approve the name. Once the name has been approved by CAC, then they will send you a code where you begin your registration. So you go to new registration now to begin your registration using that code that has been sent to your email by CAC. So once you get the code, you get to insert the code, then you begin your registration with CAC to register your business name. They will ask you for information. And if you want to register, make sure you have your national, your means of identification, which is your national identity card, your driver's license, your international passport in place. You have your passport and everything. Because this, they will require some information relating to that. They will ask you the nature of business. If I say what the nature of business, what kind of business do you intend to run? Is it agricultural business? Is it a salon? Is it general contract? So these are your nature of business. You get to see options that you get to choose while registry. So after that, you pay, you make payment. You okay, you upload your signature, your passport, then you make payment. So and there are examples of business names. You have Taiwan, Taiwo, and Co. These are examples of business names. You make payment, you wait for CAC to to look at your application. If there is no query, the company will be approved. You go to your portal and you download your certificate. So that's registration of business name. That is get you need to get the difference. Registration of business name as either a sole proprietor or partnership. Then we have procedure and documents to be submitted to CAC for registration of a company. Just like the business name where I talked about registering your account and the rest, reserving name. This also applies to company. So if you want to register your company too, that's the same thing, the same procedure I explained with regards to business name. You still apply the same procedure to registering a company. Only that this time, instead of choosing business name, you choose company, and it will ask you what type of company is it. That's why here I said a company can either be a private limited company or a public limited company, or public limited company, public limited company, uh, or it can be unlimited and limited by guarantee. But for the purpose of this class, you are advised to register a private limited company or a public limited. You are advised to register a private limited company, and a small one at that, to considering the kind of business you do. So at the point of reservation of name, you will enter the name limited company, private limited company. Sorry, excuse me. Let me check something. Sorry about that. So, as I was saying, is advisable for you to register a private limited company, a private limited company for the purpose of running your business. If you intend to register a company, not a business name. So after you must have given the name you want to register, let's say it's Johnson Nigerian Limited, since it's a private limited company, and the name has been approved by CAC. Once the name has been approved by CAC, the next step is for you to register your company. Just like business name, you go and click on new registration. New registration. So once you click on new registration, you begin your 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 registration of the company with CAC. So these are just the procedure. So just like the business name, there are informations. You need your means of identification because they will require some information from your means of identification. They will require your informations like date of birth, your name, address, who are the shareholders of the company, the share capital of the company. Share capital is just an artificial evaluation of the company that your company is worth 1 million share capital. Normally, it's advisable you register with 1 million share capital, 1 million share capital. 1 million share capital is more advisable, and you share the capital between the shareholders of the company. So on the slide we have a private limited company is more suited for small and medium enterprise. The first step to registration is reservation of the proposed name. Then second is notice of approval of reserved name. That is after CAC you reserve the name. So duly you complete the forms detailing information. And okay, with private limited companies now, with the newcomer, you can have a minimum of one director and one shareholder for small companies, one director and one shareholder for small companies. So as I said, your information page of either your national identity card or driver's license is also, you need it in the course of filling the information. And CAC of recent made changes to makes a lot of changes to the procedure of registration. So you will see some information like persons of significant control, like that the persons who have more than 5% of shares in the company, you have to enter their name. So there are some technical things that you might have difficulty understanding and the rest. I'm not saying you cannot do it yourself, you can do it. And there are something we call objects. CAC will ask you for objects of the company. So you need to know what the objects of your company are, what you intend to use the company for. That are your objects of company. So you get to list everything. Then there are articles of association. So article of association is there to regulate the relationship of the company within its members. So you can just adopt that of CAC. There's no need for you to bother yourself. So after you must have filled all the necessary information on the website, then you upload signatures, you make payment, then you submit your documents to CAC. So CAC will have a look at. If there is any information you fail to enter correctly, they will inform you that okay, this information you entered is not correct. You need to you need to correct that information. That particular procedure is called query. They are querying you, so you need to rectify that query. So once you rectify the query, then you will tell them that you have rectified that query. And all these things, you do them through your portal. You do them through your portal. But the good news is that uh, if you can't do it yourself, if you feel you want to register a company and you can't do it yourself, there are agents available to help you do that. So if you successfully submitted the documents and CAC approves your registration, a certificate of incorporation together with with your RC number appearing on the certificate will be on your portal. It's on your portal, so you get to download it and you get to share the soft copies with people. So this is it with registration of companies and business name. So we are done with registration of business. These are just fees for registration. These are the old fees because last year CAC came out with new regulations with new schedule of fees. So these ones are not applicable. So for the last part of our lecture, which I will quickly hurry up and round up so that we could, okay, so that we can quickly uh, finish is law of contract. Law of contract is quite a vast course at the university. I think the textbook of law of contract, the Nigerian textbook, the Nigerian textbook is like 300 pages. The foreign, I think, is like 2,000, and get up to 1,000 page. But or if it's not up to 1,000, I guess, depending on who the author is, it's up to like 500 if I'm not mistaken. I don't want to lie, but it's much. And the contract is a big course for anyone studying uh, law, like it's the foundation course. So this what we are just doing here now, because most of you will register business, so you need to know what are the basic elements of contract, because you have some misconceptions about contract as is when we sit down and write with pencil and biro and it's on paper, blue and white or black and white, then you will see there's contract. No, that's why you need to have basic understanding of contract. So let's quickly look at is an contract is an enforceable legal obligation agreed upon by parties. So it must be agreed, there must be agreement between parties. It must not be forced on somebody. So what are the basic elements of contract? One of the basic elements, there are three basic elements of contract. We have offer, acceptance, consideration, whereby a party makes an offer to another person, then the person accepts the offer. Offer takes different forms. Offer can be you making an offer to another person. It can be that person making an offer to that other person, depending. Let's say Mr. Johnson now can make an offer to Mr. John to sell his car, or Mr. John can approach Mr. Johnson that he wants to buy his car. It's all offer. Or where government will call for tenders, you submitting your application, you are making an offer to government. When you go to supermarkets, you see products on the shelf. When you take that product and you take it to the cashier, you are making an offer to the cashier that you want to buy this product. So you can see offer takes. So there must be offer. Then the second is acceptance. You must accept. After you accept, then there is what we call consideration. You must make payment. So once there is payment, these are the three basic elements of contract. Once they are present, after maybe they will look at is there duress and other things. Those elements that are likely to vitiate of a contract. If it is absent, then your contract is valid. What are the other things that they consider? The form of the contract. Is it written? Is it oral? Because contract can be oral. Contract sometimes can be by conduct. Because over time we've been doing a business without even saying a word, without even having it in writing. But we've been doing the business over time by conduct. I'll just come and drop something, you'll just pay me. I'll just come and drop something, you'll just pay me. We will not even say anything, we will not argue. Then one day I'll come and drop that thing, then you will not pay me. Then you come and start arguing that we did not even agree orally, we did not even agree in writing. That does not mean there's no contract. As long as I can show that I've been supplying you this thing over time and you've been paying me for it. So there's contract. So form of contract can be writing, it can be oral, it can be by conduct. Another example of contract by conduct is when you stop a taxi without even saying a word, you just board the taxi. You once you get to a particular junction, you just drop and you will just give the taxi is it 100 naira without saying a word. You know that okay, from here to here is 100 naira. So these are contracts too. You might think this contract we must sit down and draft one huge. I know simple day-to-day as buying and selling a contract. Then we have capacity. The person you are entering the contract into with must have the capacity to enter the contract. The person must be of mental capacity. He must be of he must not be drunk. He must not be a minor. Even though there are exceptions to this general rule, especially for a minor. A minor in Nigeria, there is no law that says this is the age which somebody will be considered as an adult. But going by practice, when somebody is 18, you will see the person is allowed to start driving, the person is allowed to register for voters card and the rest. So these are a sign that okay, if you enter into a contract with somebody who is less than 18 years of age in Nigeria, that contract will not be considered as valid, rather it will be considered invalid. So the capacity, even though sometimes there are exceptions, as I said, where a minor enters into a contract of necessity in the sense that what is to be supplied to him is of necessity to him, that contract is valid. Then we have legality. The contract must be legal. You cannot go and enforce a contract that is illegal. Let's say a prostitute going to court says one of her customers has failed to pay her. That contract ab initio is illegal. Then there must be this intention to create legal relationship. Parties must have agreed that they want to go into contract. So privity of contract. When I say privity of contract, I'm simply saying only parties to a contract can sue and be sued. If you are not a party to a contract, you cannot sue. Mr. John and Mr. Johnson entered into a contract. Mr. Johnson is in breach of the contract. Mr. John cannot go ahead and sue Mrs. Johnson for that contract. He can only sue Mr. Johnson. However, there are exceptions to this general rule. So one of these exceptions is covenants running on land. When it involves land and there are covenants attached to that, even though you entered into that contract with a person who is not a party to the contract, even though you enter even though a person is not a party to that contract, he can sue you for breach of that covenant. As this happens most especially in estates where you see they will have law that don't erect a wall more than certain centimeters, and you go ahead and after buying the property from somebody, you go ahead and erect the property to a certain level, which the estate association or the developer will just see. If you bring privity of contract in that instance, it will not hold water because it falls under one of the exception. Then terms of contracts can be express, can be implied. Express in the sense that they are all clearly stated for people to see. None is hidden. You can see it clearly that the contract is express. Implied are terms that flow from the express contract or from the nature of the contract, even though it is not stated clearly. But from the nature of the contract, the court will say, this kind of contract, you are supposed to include this thing in this kind of contract as one of the terms. So these are terms that will be implied, though court will rarely do so. So if you look at your contract that you are entering, state all the terms expressly for everybody to see. Then what are the elements that are likely to vitiate a contract? We have duress. When you force somebody to enter into a contract by use of threat on that person or somebody related to that person, then that contract is likely to be vitiated. When you have undue influence on another person, you use that influence like there's a fiduciary relationship existing between you and the person, that the person's a banker and you influenced him to enter into a contract. In such a case, such contracts will be vitiated if the person approaches the court and say, I entered this contract based on the advice of this man and I had no intention to enter it. It was him that pushed me and the rest. Court will vitiate. When you misrepresent facts, because you want that person to enter this contract, you will not tell him the exact truth. Then you lie that okay, this and that. He enters into the contract. That one too, it will be vitiated. Mistake is not mistake in the normal sense. Mistake in the sense that maybe the subject matter of the contract is no longer in existence. Let's say Mr. Johnson wants to buy a car from Mr. John. While they were discussing and he was transferring the money, he doesn't know that the car uh, has encountered it or has had an accident. So in that case, there is what we call mistake in law because the subject matter of the contract is no longer in existence. So in such a case, the contract will be vitiated. Then how can contracts be discharged? Contracts can be discharged by performance when parties have performed their own part of the contract. Then there can be frustration too when the subject matter is no longer in existence. You are discussing the sale of a filling station at Gwagwalada and not knowing that the filling station is burned down last night and you've made payment. So in that case, that contract will be discharged by virtue of frustration because the subject matter of the contract is no longer in existence. Then we have fundamental breach. When you are in breach of the term of the contract, for instance, you ask that they supply you with an iPhone, and somebody is supplying you with the Nokia. So you see, there is a breach of the contract. The person cannot go to court if you refuse to pay for the item supplied because he is in breach. Then we have situations where contracts are ended by mutual agreement, where parties will agree that since this is the situation, we cannot go ahead with this contract. So why don't we just terminate contract? It happens when there is a force majeure, like during this corona period now, where it has affected so many contracts. Let's say parties have not even begun the contract, like payment and the rest, or supply of anything. We can reach mutual agreement that okay, since corona has affected our contract, let's just discharge the contract mutually. Finally, what are the breach remedies for breach of contract? We have damages. Damages are just monetary compensation which are paid to persons for the loss they suffer as a result of that breach of contract. Damages can be general damages, can be specific damages. Then we have specific performance. Specific performance is an equitable remedy, and it's just saying that okay, you have performed your own part of the contract. If it is to supply 90 bags of gari, you supply 90 bags of gari, and Mr. C doesn't want to pay you, and he's using the gari. What the court will do is ask Mr. C to pay you for your gari that you've supplied him because you have already performed your own part of the contract. It's for him to perform his own part of the contract. Rarely the courts grant specific performance where damages will be enough. So that specific performance is normally granted where in matters of land. That is where specific performance is usually granted. Then we have ratification, whereby the contract is altered where to suit the situation of both parties. They'll just alter the contract a little so that both parties will be appeased. Then we have injunction. Injunction is restraining a party from doing certain act. Injunction can be perpetual, it can be interlocutory, it can be interim, depending on the facts and circumstances of the case. So there are circumstances where injunction can be mandatory, whereby you are making a party to do an act. Then we have quantum merit. Quantum merit is simply saying you deserve value for the services you have offered to the person so far. You are building a house for the person. When you've reached a certain level, then the person says, no, not it's not your own fault, it's not anything, your work is perfect. The person will suddenly say, I don't want you to continue with this work. So you can approach the court for quantum merit. That means you're approaching the court for that you should be paid for the services you've offered so far to the person. Then finally, we have rescission. Rescission is where the contract is cancelled totally. That means it's not even in existence up in the beginning. The court will say that contract in the beginning, up initial, is not even uh, is void. From the beginning, they will say that contract is not even binding in the first place, and the rest. That is rescission is one of the remedies. Thank you. We are done with this lecture. So now it's time for contribution, questions. If you have any question, contribution, or any observation you want to make, now is the time. Thank you for your patience. I want to again apologize for starting a little bit 5 minutes late. I know we started because we were supposed to start by 10 minutes past 10. We started 15 minutes past 10 because you needed 10 minutes to begin your, to do your pre-lecture quiz. So we've come to the end of today's lecture. If there's any question, uh, uh, any question?
UK, UK, UK.
Okay, Mr. UK.
Okay, sir. Good afternoon, sir.
Good afternoon.
Well, I firstly I want to appreciate the speaker and lecturer for a very sound research work. My question is from your analysis of a limited liability partnership. I observed that it is likened similar to that of a company.
Yes.
Therefore, I want to ask that is there a difference between a company and a limited liability partnership? That is my first question.
Okay. Okay.
Then my
Should I
second
answer this one
question
first?
is, okay, it's okay, sir.
Okay. LLP, limited liability partnership, is mostly used when you want to go into provision of services, not buying and selling of products or something. Mostly like professional services, like you want to do a law firm, something like law firm for lawyers, an accounting firm, you get it, accounting firm, consultancy firm, a construction firm. Mostly LLPs are used for something professional, while companies are more, they are involved in buying and selling of products, manufacture, and the rest. That is when you are to consider companies. But if you want to go into providing of professional services like that of accounting, as I said, law and the rest, you can register LLP. Why you are doing that is, why are you registering LLP? So that in case one of the member decides to leave, you don't have to start changing name and the rest, or it does not affect the kind of services you are providing, or you intend to run the business, the partnership. You want the partnership to run for a very long time, just like company. So that's just the difference. Because if you want to register, you want to go into production of goods and services, you want to go into like buying and selling, something like that, I will not even advise you to say you want to register LLP. The best thing you register is a company.
Thank you very much, sir, for the beautiful answer. And my second question is bordered on the aspect of registration of products. I want to ask that where there is a clash of registration between NAFDAC and SON with respect to a particular product, what happens? Which of them will prevail?
In this case, as I said, this is Nigeria. So if you have such a situation, even though you will see their inventory might state that, okay, you have to register this product with us, then NAFDAC Act will say register this product with NAFDAC. So in such a situation, normally there should be synergy between these agencies. You get it? So that when standard organization is releasing its inventory, it should ensure that the product is releasing should not be those ones that are registered with NAFDAC. I don't know whether you understand what I'm saying, but when it appears that it appears in their own inventory and it appears in and is among one of the categories of product that register with NAFDAC, to avoid this thing, if you can do it, then you register with both to avoid any embarrassment and the rest. That's just what I can say.
Okay, thank you very much.
You're welcome. For Mr. Chiku Charles, your question on your contribution is one, the volume wasn't good enough. Well, on my part, I'm shouting here, so but we'll still work on the audio next time. Then you can still use your current business name to do whatever you want to do. You are not needed to register another business name. Thank you. Okay. Okay. Let's quiz, post quiz. Okay. Next meeting. Okay. So there will be announcement on the platform. Okay, there will be. So now I'm done with my class. Thank you very much for your questions and patience. So there will be announcement now. I will be switching off I will stop my video, and the person that will make the announcement will take over as an announcement as to regarding certain things with the program. Thank you very much for your time. Thank you.
Good afternoon, ladies and gentlemen. We want to congratulate you, the management of Citron Nigeria Limited. We appreciate your time with us. The training manager, person of Dr. Buche, who was unavoidably absent due to some programs he has to handle, send his warm regard. It's our belief that the 1 week long training has been so impactful. Thank you, Barrister Ilana, for the wonderful lecture you have delivered. The management of Citron Nigeria Limited wishes to inform you that there will be graduation tomorrow. Officially, today marks the end of a 1 week long training. The graduation as well will be on the WhatsApp platform, this time around, not the Zoom. Part of what you're expected to do during the graduation is that the WhatsApp portal will be open for exhibition. What's the exhibition all about? The essence of this training is for business and connection. You may have a product you want to portray or show your co-member on this training platform. So you'll be given that chance to showcase your different businesses. And then you'll be given the chance to meet your co-trainee one-on-one. Okay. So on the WhatsApp platform, more information on how the graduation will be done will be posted in subsequent time. Immediately after the exhibition, your certificates will be issued to you. On this note, we congratulate you, and we must say the 1 week long training with you has been so enjoyable to us, and we believe you will enjoy the same benefit. Thank you very much. See you tomorrow at the graduation. Bye-bye.